Convener for Democracy Hub, Oliver Barker-Vormawor, has apologized for his allegation of bribery against the Appointments Committee of Parliament. The social activist was summoned before the Appointments Committee on January 29, 2025 to substantiate allegations of committee members demanding money from ministerial nominees. ChannelOne News' Charles Owusukumi was there and reports.
The Appointments Committee on Wednesday cleared its schedule to make way for its engagement with convener of Democracy Hub, Oliver Barker-Vormawor. Now, the committee has summoned Oliver to come and substantiate some allegations of bribery that he, Oliver, had made on his social media against members of the committee. Now, during proceedings, Member of Parliament for South Dai and the Majority Chief Whip, Roxanne Nelson Dafiameko, raised questions of jurisdiction of the Appointments Committee to probe matters of contempt of Parliament.
As a committee, we do not have the mandate. I believe that another committee of Parliament has the mandate to deal with the merits of this matter. And having admitted to the statement or one of the statements in question, Mr. Chairman, with all due respect, we would have made a referral to the appropriate committee of Parliament, which is the Committee on Privileges. Then we can proceed with our mandate, which is to vet.
Despite these concerns, the chairman, Bernard Ahiafo, ruled that the sitting continues.
We took a decision as a committee to invite Oliver Barker-Vormawor to produce evidence to substantiate his allegations. Oliver Barker-Vormawor and the lawyer both agreed to render an apology to the committee. Honorable members, the meaning that I gathered from that is that whatever he has admitted to be his post, he doesn't have any evidence to substantiate it. That is why he wants the opportunity to apologize and withdraw the statement.
Oliver, who was represented by his counsel, a former chief of staff in the Rawlings administration, Nana Ato Dazi, sought to explain the context of his social media post.
And he has an obligation to expose, what he sees, just to be just an observer. So what he's seen, I think that under the general rubric of citizenship, he is expected to put it out. It's a liberty to put it out and to advocate that that practice should stop. In which circumstances I would think that a person who comes forward to say that the Honorable Appointments Committee, their honorable job is being affected by some other person, third parties, it should be commended. Under the Whistleblowers Act, he probably will need some compensation for services rendered, really. But I mean, without making it sound like on a serious matter, we're saying that this statement here and the way it's been put out, as though he intended to vilify this honorable committee, is certainly very far away from what he intended the post to be.
The Appointments Committee, through ranking member and minority leader Alexander Afenyamakin, provided Oliver Barker-Vormawor a window of opportunity to apologize for his comments.
Are you here with an unconditional apology on the ownership of the other statement? An absolute one, unconditional. Say so in clear language. Let's leave here.
After a brief exchange between the minority leader and Oliver's counsel, Oliver Barker-Vormawor, finally apologized to the committee.
I am saying here clearly that my post was not intended to disparage members of the committee, and I have not intended to say that members of this committee have received or demanded bribes from various individuals. At no point was my statement intended to communicate same. And for those reasons, I apologize.
The Appointments Committee will now continue with the vetting of ministerial nominees on Thursday, January 30, 2025. From Parliament House, General Charles Osukumi for Channel One News.
Right, so now let's get more on this by speaking to Victor Adawudu, one of the lawyers for Oliver Barker-Vormawor. Thank you very much, lawyer, for joining us. Now, was it really your client's intention to apologize, or you think it was due to the posture of the committee?
No, actually, there were two. It was his intention that, looking at the circumstances, what he had posted was subjected to variety of interpretation. So he just wanted to apologize for the post that he uttered.
But why would he post something that he can't substantiate? Was it just for attention?
No, for attention. You see, sometimes we didn't want to go into the legalities of it, because what he posted, by his activity, people draws near to him. He draws people near, and people come to make some allegations. Some they give him some facts and the rest. But he's also a person who will not want to disclose some of his sources or some of the things they told him. So if you look at the post, actually, it asks if that is what is happening within the committee. It was conditional. Now, if you want to push into the legalities, how to come and substantiate, and you don't also want to disclose your source, people who give you the information on which you act, I think that it gets to a point, irrespective of the fact that you think you have some rights, you may have a right, but you may not approach it or the right approach. Maybe it's the wrong approach that you may go through it. You look at it and count and see what would be beneficial to me and what would also be, I'll be able to protect my source. So I think we actually went there in a mind that, yes, but also to state that the other document that was authored, which was a reportage, did not come from him.
Right, that he stated clearly.
Yes, he clearly made that. Yes, and we clearly made it that, look, it's from different sorts, and the committee itself can investigate and look at what that document, where it is coming from, whether it's coming from the people. And I think that it would be good that the committee look at that, so that we've had all these issues from every appointment committee when they go for public hearing. The people, bits and pieces of information, and like money is being dropped. The money, they ask for money ostensibly to be given to members or people, even nominees. Nominees become worried what they have to do. And till date, even when a committee was set, members of parliament, original members made those allegations. Nothing came out of it. So it still remains, and we need to find a solution to this. So I think that if this one they investigate and find the other source, where it came from, I'm sure that we'll bring this thing to.
So for the post that he apologized for, has he pulled it down? Will he pull it down?
Oh no, yes, he will pull it down. He's going to do the disclaimer after the second one, and I'm sure whilst it is done, we would write to the committee. Once we give it to the committee, they will fall. But I'm also very sure that the committee itself, at least the whole world, knows that what is being said, they've been absolved. Nobody from the committee has taken money from anybody, and the intention was not to say that the committee or its member leadership have taken money. I think it was to draw attention. But the choice of words, I think that's what I said, subjected to variety of interpretation. That's what brought us this far.
Right, so we're still on this case, and we've been joined by a member of the committee and MP for Daboya Mankarigu, Shaib Mahama, to also share his views on the proceedings. Thank you very much, Honorable, for joining us. Now, would you say that the committee is satisfied with the apology given by Mr. Barker-Vormawor?
Good evening, to your cherished viewers and listeners. Yes, the committee is satisfied with the apology that was rendered by Mr. Vormawor.
Does that mean that the case is resolved? We are not going to have to raise it again and refer it to Privileges Committee?
As things stand, yes. With respect to the aspect that he showed ownership, that is fine. But there's a second aspect that we may want to look at, so which he has clearly and completely dissociated himself from.
But really, moving on, how is Parliament going to ensure that we do not encounter such cases? Because it really denigrates the integrity of the House.
Well, that has to do, it's a public image thing, and it didn't start from this Parliament. It appears that every cycle of appointments, you have this allegation lingering on. And I remember in the 7th Parliament and even in the 8th Parliament, we have cases of people alleging of, and it goes a long way to dent the image of Parliament. And so this particular one was just to let the world know, I mean, anybody who has evidence to back a claim should come clearly and make that. But if you just put it across without any evidence, we thought that the world needs to know, Ghana needs to know that the image of Parliament cannot be taken for that.
Well, thank you very much.
Going forward, I mean, we think that the public need to help us. Perception of corruption permeates not just Parliament but many other places. Where there's clear evidence of any wrongdoing in terms of corruption, at least provide the evidence, and that will suffice. So we urge the public to come out clear and clean if there's any sufficient evidence to nail any member or chairman of the committee in that respect.
Very well. Please hold on there for me. I'll get back to you shortly. But lawyer, there were arguments, challenging the jurisdiction of the committee to call your client in the first place. What are your thoughts on this?
You see, the law is not like 1 + 1 is equal to 2. It depends on circumstances. But I think that the point that the majority chief whip was making as to the jurisdiction, it was solid in the sense that you cannot be a judge in your own cause. So it is the committee that now says is making the complaint, and they themselves will now be the persons questioning. I think that we needed another person. That's why the Committee on Privileges and Assurance that has that committee that will have to do. But they are also saying that they only invited him to just substantiate and say that this is true or it's not true. So I think that that committee, as at that time, it was not that they were going into a trial. It is just to make sure and that the information that we have, whether it is true or not. So if you look at it, that's why we didn't want to get into the legality. All we went was to apologize. And I think that for me, I should also thank the leadership of the committee. Because in spite of the arguments, it was heated from some time between but they realized that we needed to bring this matter to close, especially for us. We didn't want to be seen as people derailing government business or forestalling, because if they hadn't finished with this, business will not go on.
Right.
But I think that the legalities, yes, what the issues that all of them raised were legal points that could be debated and see. But lawyers, when we debate until we have a third person, the arbiter, the matter is not resolved.
Exactly, it's hanging. But a section of the public suggests that the whole posture of the committee was to intimidate your client. Do you share this opinion?
No, I don't think what my clients are gone through for the past few years and what he stood for, I don't think that they could have intimidated him. What the court had even done or he was taken through the court has toughened him as a person. I think that he has some philosophy that he wants to put his cases across. But I think that what my client will need is maybe the finesse and the ambience. But you see, he's leading a group of people who majority of them is at the grassroots. And you know, when you want to speak in the grassroots language, the layman's language, he doesn't speak like a lawyer when he meets them. So those are the things that he needs to find a fine balance between the grassroots and taking notice of his profession as a lawyer.
Right.
Because he may be questioned that our ethics doesn't allow some of the things, and people will question and say, you are a lawyer, you knew the consequences of this. But it's also appealing and speak for some targets. So I think that he will be able to know the fine balance between them.
Right now, Honorable, if you can hear me loud and clear, you know, while a section of the public think that the posture of the committee was one of intimidation, others also believe that Mr. Barker-Vormawor should be served as a scapegoat, you know, to deter others from making such comments in future. What do you think about this?
Well, I mean, scapegoat is a strong word. Following from Senior Dawodu's comments, ab initio, the committee knew that it was purely inquisitorial. We are not cloaked with authority to do any hearing of the sort, you know. And so we were not there to victimize Mr. Vormawor.
Right.
Indeed, his was just to substantiate. And if you check the tone of the letter, the invitation that we gave him was to the effect that please come and substantiate the allegation that you have made. And so you may find some voices raised at the committee, but it purely was not to intimidate Mr. Vormawor. Of course, I mean, it also serves to the general populace that you will need to have credible evidence before you can make an allegation against an institution or an individual.
Right, thank you very much, Honorable Shaib Mahama. And I will also say thank you very much to you, Lawyer Victor Adawudu. Thank you for coming.
It's a pleasure, and I don't take this platform for granted.